Hi, my name is Untitled Chapter. I'm your lecturer for PUL 446 Evidence 2. Today we are going to examine another topic in the law of evidence, and that topic is character evidence and similar fact evidence. We will look at the definition of character and examine character evidence in civil and criminal proceedings. We will also examine similar fact evidence and exceptions thereto. I believe you will enjoy today's lecture. Thank you. Thank you.
You're welcome to today's lecture once again. Today we are looking at character evidence and similar fact evidence. At the end of this lecture, you should be able to define and explain character, discuss character evidence in civil and criminal cases, and discuss similar fact evidence. Let us define what is character. For that purpose, let us look at section 77 of the Evidence Act. It says in section 78 to 87, the expression character means reputation as distinguished from disposition, and except as mentioned in those sections, evidence may be given only of general reputation and not of particular act by which reputation or disposition is shown. So as far as the law is concerned, character means reputation of the individual. It doesn't mean his disposition as an individual or his personality. It has to do with his reputation. Now if you look at that definition, so it means that somebody may be of good reputation, but yet is of a bad character, because what the law is concerned with the reputation of the individual. And somebody may be of good personality and yet he has a bad reputation, and then means bad character because one particular incident or case of previous conviction amounts to bad character. That is the position of the law. So that definition may not be entirely satisfactory. Let's look at character evidence in civil cases. And for that purpose, let's look at section 78 of the Evidence Act. It says, in civil cases, evidence of the fact that the character of any person concerned is such as to render probable or improbable any conduct imputed to him is inadmissible except insofar as such character appears from facts otherwise relevant. So in civil cases, the character of an individual is actually not relevant and therefore is not admissible. The only exception is that if it is relevant to the fact in issue, that is only when it can be admitted in evidence. So character of a party is generally relevant in civil cases, except where it is relevant. It may be relevant where, for example, in a libel suit, the defendant pleads justification. In that particular situation, the character of the plaintiffs or the claimant becomes an issue, becomes a fact in issue, which becomes a matter of dispute between the parties. In such circumstances, then the character of a party in a civil suit can then be relevant. Again, if you look at section 79 of the Evidence Act, it says, notwithstanding section 78, in civil cases, the fact that the character of any person is such as to affect the amount of damages which he ought to receive may be given in evidence. Let us say that the issue now boils down to amount of damages which a party is supposed to be entitled to. Then the court can receive evidence of character in respect of such an issue. Now let's look at character evidence in criminal cases. In criminal cases, let us look at section 81 of the Evidence Act. It says, in criminal proceedings, evidence of the fact that a defendant is of good character is admissible. So in criminal cases, the good character of a party is admissible in evidence, but the bad character of a party is not admissible in evidence. The court forbids the admission of bad character of an accused person in evidence, subject to certain exceptions. Now let's look at section 82, subsection 1 of the Evidence Act. It said, except as provided in this section, evidence of the fact that a defendant is of bad character is inadmissible in criminal proceedings. So in a criminal proceeding, evidence of bad character of the accused person is not admissible in evidence. Okay, but evidence of his good character, like I have pointed out, is admissible in evidence, and that may be helpful in doubtful cases, in a situation where there is doubt as to whether the accused person committed the offense or not. But in a situation where the case against the accused person has been proved beyond reasonable doubt, evidence of good character may not really be of much help. And that is why Noakes said that in his book, that if an alarm of theft is raised at a charity bazaar and the thief slips a stolen purse into the pocket of the bishop, the episcopal character may allay suspicion. But if a bishop should be caught in the act of shoplifting, the episcopal character would merely appear unmerited. So it simply means that where there's doubt as to whether an individual committed a crime or not, then the evidence of good character may be of help. But once it is shown that it is the accused person that committed the crime and the matter has been proved beyond reasonable doubt, then evidence of that person's good character may be of no consequence. Now let's look at the case of R versus Fordley. In that case, accused was charged with housebreaking with intent to commit rape, and evidence that the accused on the same night came down on a chimney of another house and had intercourse with one of the inmates with her consent was received by the judge, and the judge considered the evidence as of some relevance as shown lustful disposition. It was held on appeal that the evidence was irrelevant and therefore inadmissible. The fundamental reason for excluding character evidence is that character evidence may prejudice the mind of the court against the accused person, and rendering the accused person rendering the court prone to the hasty conclusion that the accused person committed the instant offense. So that is the rationale for excluding character evidence, to prevent bias, to preclude hasty conclusion on the part of the court that it was the accused person that committed the offense. In the next slide, you will be required to provide an answer to the question provided therein. Let us first and foremost look at exceptions to the claim that in criminal proceedings that the character of the accused person is irrelevant and therefore is inadmissible. And particularly, let's look at section 82 subsection 2 A and B and subsection 3 3 of that particular section, when the accused character is a fact in issue. Whenever the accused character is a fact in issue, then the accused character is admissible in court, and in that circumstance the accused character is relevant. Now if we look at the offense of being a rogue or vagabond under section 250 of subsection 1 of the criminal code, in such a case there must be evidence of previous conviction of being an idle or disorderly person. Under section 249 of the criminal code, a previous conviction is thus a fact in issue. So we have seen that in certain circumstances, when the accused character is a fact in issue, previous conviction or bad character becomes relevant and therefore admissible in evidence. Equally, when the accused gives evidence of his good character, then evidence of his bad character becomes relevant and therefore admissible. What the law gave with the right hand, it took with the left hand. The law is that the accused bad character is inadmissible, but whenever the accused gives evidence of his good character, then evidence of his bad character becomes admissible in court. But it must be noted that the evidence of his good character will be for the purpose of rebutting the evidence of his good character and no more. That is the position. Like I pointed out earlier on, we need to look at the class activity for this lecture and provide an answer to it in the next slide. Discuss character evidence in civil and criminal cases. Let us look at similar fact evidence. What is the meaning of similar fact evidence? You see, similar fact evidence is similar to character evidence, and the attitude of the law is that of general prohibition. The law prohibits evidence of similar fact evidence because it tends to show that it was the accused that committed the offense which is an issue. So similar fact evidence, like I pointed out, is excluded. So similar, and it can be said to be that a fact bearing a semblance with a fact in issue, and its purpose in the law of evidence is to show that the person whose conduct is a fact in issue had previously been involved in such disputed conduct. The attitude of the law is also that of general prohibition. That is the position of the law, except in situations where the law provides for exceptions to that general fact evidence. And this principle of general facts of exclusion of similar fact evidence is actually contained in the case of Markin versus AG for New South Wales, 1894, AC at page 59. Let's look at exceptions to similar fact evidence. One of the first exceptions is to rebut accident, because when a matter is brought before the court against the accused person, the court with the prosecution will not only prove the case against the accused person, the prosecution must also negative accident, because an accident is one of the general defenses in criminal law. So whenever the accused person pleads accident, it is the duty of the prosecution to show that the conduct or what the accused person did was not accidental. Another exception is to prove knowledge. If the accused person is saying that he didn't know that what happened is within his knowledge, evidence can be shown that he actually knew, or he ought to have known, that the consequences of his conduct will lead to that, or he knew what he was doing. It also helps to show system. It's a particular system of conduct. It helps to prove identity. In the next slide, you will be required to provide answer to the class activity therein. Discuss the exception to the exclusion of similar fact evidence. In this lecture, we have looked at the definition of character evidence, and we've seen that in civil cases, character evidence is inadmissible except in certain cases. For example, in libel suit where the plaintiff or the defendant pleads justification. In that particular instance, the character of the plaintiff becomes an issue. In criminal cases, character evidence is also excluded, subject to certain exceptions. And we've also examined similar fact evidence and the exceptions therein. I hope you've been able to find the lecture interesting. Thank you.